Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's video. Today I'm going to be talking about a recent case that was decided by the Tennessee Court of Appeals last week, or was published by the court last week, involving a business contract dispute. And so this case is of interest to any company, any business in Tennessee that wants to keep abreast of things that are happening in the Tennessee courts with respect to contract disputes. The name of this case is Cunningham versus Sun Ice Inc. And Sun Ice Inc. is a company that is from Canada, formed in Canada, and principal place of business in Canada. Mr. Cunningham was a Tennessee resident who had contracted with Sun Ice Inc. to be a representative to market Sun Ice's clothing line at PGA events throughout the country. And he did that, and apparently after about 18 months of operating under this contract and having received mailings from the company of clothing samples and things of that sort, and also getting paid under the contract, getting checks in the mail from Sun Ice Inc. there in Canada. Sun Ice Inc. Decided to unilaterally terminate the contract with Mr. Cunningham. Mr. Cunningham sued Sun Ice Inc. and Sun Ice Inc. Filed a motion to have Mr. Cunningham's case dismissed because of lack of jurisdiction over Sun Ice Inc. The main argument was, we are a Canadian company, we don't do business in Tennessee, we don't have any employees in Tennessee, we don't have we basically have no contacts with Tennessee, and so under the due process clause of the federal and the state constitutions, we should not be subject to being sued in Tennessee. And the Court of Appeals in Tennessee decided, yes, Sun Ice Inc. is correct. There aren't sufficient minimum contacts between Sun Ice Inc. and the state of Tennessee to allow Mr. Cunningham to bring his lawsuit against Sun Ice Inc. in Tennessee. So this points to a real important issue, that if you are a business or a business person and you're thinking about entering into a contract with a company that is not from Tennessee and has no business connections to Tennessee, you want to be careful, because if you later want to file a lawsuit or seek some kind of remedy from that company for a breach or an alleged breach of contract, then you may have a problem, because if there's not sufficient minimum contacts with the state of Tennessee and that company that you would be potentially suing, then that company may be able to get the case thrown out or dismissed. So what is the main takeaway from this case? I would say the main takeaway is to be, first of all, to be cognizant of the important fact that if you are entering into a contract with a company that's not local, that's not a Tennessee company, and particularly if that company is not a U.S. company, you want to make sure that, if possible, you know that that company has some connection with the state of Tennessee, either a location in Tennessee or employees in Tennessee, or is doing business in Tennessee. If it's not, then you might be opening yourself up to the same problem that Mr. Cunningham found himself in the case against Sun Ice Inc. The second point I would make is that if you are at the point of negotiating a contract with a foreign company, a non-U.S., a non-Tennessee company, and particularly a non-U.S. company, you want to see if you can negotiate the inclusion of a provision in the contract with that company that they agree to have any disputes governed by Tennessee law and subject to hearing in a Tennessee court. That might be a difficult provision for you to get that foreign company to agree to, but at least if you're aware that this could be an issue, you can raise it with that company that you're talking about having a contract with. All right, so I hope that helps, and if you have any questions, please feel free to call, and we'll talk to you next time. Thanks.